can't hear my dulcet tones, many of you know me, so I'd be surprised if you can't hear me. So put your hand up if you can't hear, otherwise I'm going to put this down. Just so you all know, the barrister I know pretty well, not seen him for many years, but I was sitting in Manchester Crown Court last year, and my usher came in and mentioned this particular barrister because in more recent times, one of the joys he has, although perhaps in part a frustration, he has days out and comes to Manchester Crown Court to look at other barristers and judges, and the usher knows him and everyone accommodates him because, you know, we all of a generation, I remember him as a young man and I remember the tragedy of the accident, and the important thing that Michael says is just remember, lawyers, carers, case managers, you can all make a difference. In whatever small way, we can all make a difference. I'm now going to talk to you about a very new topic, vulnerable witnesses. In the past, mine, Michael's, brain-injured claimants in litigation would very rarely give evidence. Why? Well, we don't want to put them in a position where defendant's barrister is going to be horrid to them, score points, and then say to the judge, he says he's all right, doesn't need this, and that is the end of the matter. Equally, defendants would like to have a window of insight into a claimant, because the insurers very rarely do. And often they can get that opportunity if they have some evidence from the claimant. So that is where we were, and in my view we've moved on. I've been sitting as a judge for 20 years now, and I sit on serious sex cases for the last 6 or 7 years. And the one thing I have seen as a criminal judge is that you can have every facility given to individuals, vulnerable people, not only children, but adults, so that they are able to give evidence. And in the criminal courts, that's delivering evidence of some particularly unpleasant crime, so they can describe the events to the jury, and ultimately it is then for the jury. ABE, achieving best evidence, that is what ABE means. Whether a witness, however, is competent to give evidence is a matter for the trial judge. The question for the judge is whether the witness can understand the solemnity of the oath and give proper answer to questions. In other words, does he understand that he's there or she's there to tell the truth and what that means? And when asking questions, is that person able, as we say, to give proper answers? Well, in my view, most times, individuals with brain injuries will be competent to give evidence. It'd be blatantly obvious if they're not. However, if a claimant is viewed as competent, he's nonetheless vulnerable. And there are likely to be, in my view, significant barriers to him or her being able to effectively participate in the proceedings without assistance. Forgetting capacity, whether they've got capacity or not, that perhaps is dependent upon the extent of the assistance needed. But the court has general powers, case management powers, and has the duty to act in accordance with the overriding objective, which empowers the court in civil proceedings to give directions and to enable any evidence the claimant might be provided in a way that ensures the overriding objective is achieved. The overriding objective, of course, being to achieve justice and fairness between the parties.
And this is in accordance with the ABE principles, now well established in the criminal jurisdiction. If you ask criminal solicitors and barristers about ABE, they're really up to speed. They know all about it. The barristers know about the gateway. They can go on and what questions and how you should ask a question. You ask the civil solicitors and barristers, they've not a clue. Genuinely, not because they're disinterested, but it's never crossed their radar. And in my experience now, it should cross your radar and is very important. Because whilst there are no statutory powers in the civil jurisdiction equivalent to those you find in the criminal court, there's no issue of principle that precludes a court from seeking to achieve parity in terms of recognising vulnerability and putting into place measures to address the same. And over the last 6 to 12 months, I've been raising these points with High Court judges, and not a one of them disagrees. Registered intermediaries. You may form the view that a report from a registered intermediary, jointly instructed or otherwise, is needed, and you'll hear from Louise in due course. This is to provide guidance to the court as well as the legal representatives, in particular the cross-examining barrister. Now, I'm not going to trespass on Louise Sheffield's pitch, but she and others have a very important role, even intermediaries needed. In many cases, however, you don't need one. That's a judgment call you will make as the lawyers, perhaps with the expert opinion from your medics. No objections can be taken, because someone's competent, to questions being put to the claimant, subject to the points of relevance. In the past, as I say, many have not given evidence because of this unfettered and unrestrained cross-examination. In modern courts, this need no longer be the position. Judges are trained now, certainly in the criminal courts, to be interventionist, and in the civil jurisdiction, the same. So you, whichever side of the fence you're on, can't just fire bullets just for the sake of it. In fact, many claimants, of course, want to give evidence, and their representatives see this as a sensible and measured way of actually giving the judge some insight. I have many clients who say, over the years, why can't I give evidence? Well, I think it'll be a bit too difficult for you and upsetting. And it would be, going back 5-10 years. And I wouldn't put any individual in that position, because you all would not like being in the crow's nest. You wouldn't like it. You can see everything. I know as a judge, and my pupil Catherine Dempsey has been sat on the bench with me, looking, you can see everything. There is no way to hide. Very exposed. You'd be nervous. Trust me, most of you would agree. If Michael Redfield's asking you certain questions, you would ultimately agree with some of the points he's made. And then you go out to court going, why did I agree to that? And there's nothing wrong with you. So it's difficult. Fatigue. Forgetting any other cognitive issues an individual may have with a brain injury. They get tired. They're working on, instead of 4 cylinders, they've got 2 or 3 cylinders working to run that engine. They get tired. They'll need breaks. Of course they will. Defendant, I say, should indicate to the court in general terms how long you expect to be cross-examining the claimant. It's often better for the claimant's evidence to proceed in the morning, rather than towards the end of the day, again, in order to achieve best evidence, when he or she's tired. And this can easily be achieved by claimant giving evidence on the morning of day 2 of the trial, because you can always accommodate that. There'll be an opening to the judge may want some reading, you'll have other witnesses. And the judge is more than capable of hearing other witnesses out of order to fit in so we can hear the claimant on the morning of day 2. Cross-examination. The court should be asked to manage the extent and the length of the cross-examination. Like you'll have read in the paper, in rape trials, God of the days, when barristers can have the female victim in the witness box for 1 day or 2 days, going through things time and time again. It is no longer permitted. Many points can be dealt with by medical experts, other lay witnesses, and some will be matters for submission based upon the documents including the clinical records. So asking what's already in the clinical records, for someone who's brain injured and vulnerable, what's the point in asking the question? The wife, partner, support worker, case manager may be able to answer many of the questions the barrister for the defendant thinks that should be put to the claimant. So the information comes out just by a different vehicle. So what I do, I ask the counsel for the defendant to produce to the court, preferably in writing, the topics to be covered in cross-examination. The points within such topics, where appropriate, provide a general guide as to the questions being asked and the intended wording, particularly with a vulnerable, suggestible and susceptible witness. It's a lot easier if you've got an intermediary saying what sort of questions can or cannot be asked, but many times you won't have that. And the barristers go, I'm not going to tell you what you're going to ask. Is that the reality? Well, actually, no. Most defendants' barristers say, because I say to them, if you don't want to tell me, tell the judge. And you can tell the judge in confidence, and the judge can have a look at it. And all the barristers say, no, we don't have a problem. You can see them, because with respect, it's blindingly obvious the sort of questions they want to ask anyway. So I can work it out. But it's not just the topics, because I'd be able to say, oh, hang on a minute, that can be dealt with by his wife. Or, why do you want to put it in that way? And Louise will talk about tag questions. You like going to the shop, don't you? Barristers in the criminal courts have had to rebrand themselves. And I don't bark at them now in the criminal courts because most of them are switched on, but sometimes the older barrister, you have to stop them. Send the jury out, just a minute. But the way to nip it in the bud as a criminal judge is I get a list of questions. Particularly, you can imagine if it's a sex case involving children. I'll say, well, what are you going to ask? So we have a list of the questions. I say, well, you can ask that. You can't ask that at all. And I'll let you ask that, but we'll have to redraft it. And you can make submissions. And does that actually make a difference